Note on right to strike. The recent Kerala High Court ruling has once again brought attention to the contentious issue of the right to strike, especially in the context of government employees. The court emphasized that participating in general strikes, which disrupt public life and strain the public exchequer, is not protected under Article 19(1)(c) of the Constitution. Such actions also contravene the Kerala Government Servants' Conduct Rules, 1960. While the right to protest is a fundamental right in India under Article 19, the right to strike remains a legal right with statutory restrictions under the Industrial Dispute Act, 1947, now subsumed under the Industrial Relations Code, 2020. Question and answer. Q1. What is the legal status of the right to strike in India? A1. In India, the right to strike is not a fundamental right but a legal right. It is subject to statutory restrictions under laws like the Industrial Dispute Act, 1947, and the Industrial Relations Code, 2020. The right flows from the fundamental right to form unions but is not absolute and can be reasonably restricted by the state. Q2. How does the right to strike relate to international conventions? A2. The right to strike is recognized by conventions of the International Labour Organization, ILO, of which India is a founding member. These conventions acknowledge the importance of strikes as a tool for collective bargaining but emphasize that it should be used as a last resort. Q3. What are some key Supreme Court judgments on the right to strike? A3. In Delhi Police v. Union of India, 1986, the Supreme Court upheld restrictions on forming associations by police forces. In T.K. Rangarajan v. Government of Tamil Nadu, 2003, the court ruled that employees have no fundamental right to strike and upheld prohibitions under the Tamil Nadu Government Servants' Conduct Rules, 1973.
Come find me.